This is Chapter 5, Business Entities and Formation. There will be two videos for this chapter. This chapter I only explain about the business entities in Malaysia. The forms of business entities. In Malaysia, the business can be registered under Business Registration Act 1956, Amendment 1978, and Procedures of Business Registration 1957. Another act is Company Act 1965, Cooperative Act 1948, and Parliamentary Act or State, which is Government Enactment. There are few types of business entities, which are sole proprietorship, partnership, limited company, whether by guarantee, share, or unlimited company. Some of these business entities subject to different business act in Malaysia. For example, for sole proprietorship and partnership, the sole proprietorship is a business that has only one owner. These two types of business are subject to Business Registration Act 1956, Amendment 78, and Procedures of Business Registration 1957, while for the limited and unlimited company, it is subject under Company Act 1965. In this chapter, only three forms of business entities are discussed, which are sole proprietorship, partnership, and private limited company. Private limited company is a company that has Sendian Berhad at the end of the name. A sole proprietorship is formed under the Business Act 1956, Amendment 78. This form of business structure is solely owned by one person, where management rests on that person whose liability is unlimited. A sole proprietorship is by far the simplest business structure, but that does not mean that the sole proprietorship has to be small. A sole proprietorship may have any number of employees or may grow to any level in sales revenue. Okay, for example, the Maidin store, which is now a multi-million ringgit business, it was actually a sole proprietorship business before it became private limited company, which is Sendian Berhad. As for the name of the business, the name of the owner or any other name may be used. Normally, a sole proprietorship business requires a small amount of capital to start with compared with other forms of business entities. For example, the sole proprietorship business are tailor shop or business saloons, restaurant, laundries, mini market, and others. So there are certain advantages and disadvantages of a sole proprietorship business. For the advantages of sole proprietorship, it is easy to manage. This is because the owner or proprietor can make decisions by himself. For example, the decision to buy certain things or to invest for the company. So he or she don't have to get approval for any member because there is only one member in that company, and any decision is easy and quick to be made. Then the owner enjoys a certain degree of flexibility, since as a sole owner, he can react quickly and positively regarding necessary changes in the business. For example, the restaurant owner during COVID-19 pandemic, where most of the people just stay at home, so the owner can quickly change the business service that suit with the situation. For example, by using delivery service, update the menu with affordable packages since many people affected financially, and other strategies. Then it is easy to form and dissolve with minimum formalities. For example, if you want to do business, just go to CCM, which is Companies Commission of Malaysia, or Suruhanjaya Syarikat Malaysia, SSM. And if you want to dissolve or closing down the business, you don't have to renew the SSM, or the best way is to go to SSM and terminate the business. And as nobody shares the rewards of the business, all profits will go to the owner, then not subjected much to government rules and regulations. For instance, the yearly financial statement does not require validation by a qualified auditor. If Sendian Berhad Company, they have to hire qualified auditor to verify the financial statement. And the owner pays income tax based on his total individual income. If income drop, then the owner pay less, and if the income or revenue increase, so more tax he has to pay. The disadvantages of sole proprietorship: first, limited source of capital that could limit the business activity. If in partnership, every member or every partner contribute their capital, but in sole proprietorship, one owner only, so limited source of capital. Then the liability of the business is unlimited. If the business incur debts for which the business assets are not sufficient to cover, The owner must be prepared to settle the debt with his personal assets. For example, the house or the land, which are the personal assets of the owner, might be affected if the company cannot afford to pay the liability or debt. The other disadvantages is the future development of the business is limited and depends on the management capability of the owner and the condition of his health. The owner is solely responsible for carrying out all the tasks, therefore a lot of time and effort needs to be spent in managing the business. The lifespan of the business depends upon the age of the owner and how efficiently he manages the business. In addition, the business will be dissolved if the owner passes away. If someone wishes to continue the business, then he has to re-register. As a sole proprietorship business becomes bigger, the entrepreneur may find it necessary to choose another form of business entity. The business might want to raise larger capital, diversify its functions, and share risk, so the partnership is the good business entity to form with. A partnership is a legal business entity with two or more partners. In this form of business, a person forms a partnership with one or more persons to carry out a business with a view to making profit. A partnership business is also incorporated under Business Registration Act 1956, Amendment 78. Similar with the sole proprietorship, a partnership is carried out by more than one person but not exceeding 20%. In a partnership, partners agree to undertake a joint business and jointly own the business. However, in professional businesses such as legal firms, architect, and accounting firms, the members could number up to 50%. In this form of business entity, the partner carried out the business, share the capital, profits, and losses. Every partner is considered the company's representative and acts on behalf of the company. Similar with sole proprietorship, in partnership, there are also advantages and disadvantages. For the advantages, first, it is easy to set up with few formalities. It is not too easy as sole proprietorship, but more easier compared to private limited company, which is Sendian Berhad. And then easier to secure financial assistance from financial institution compared with sole proprietorship. The financial institution or banking sector are more convinced to approve the loan from partnership business than sole proprietorship. Another advantage is the equity can be increased through enlisting additional partners. If the company want to increase the number of asset or cash equity, then they can add a new member or new partners. The business risk can be reduced and distributed among partners. In case of losses, each partner will share the burden, so it is not fall under one person only. The responsibility of managing and handling the business can be divided equally among partners. A lot of ideas, talents, and skill can be pulled together for better management. And as in a sole proprietorship business, income tax is not imposed on the partnership itself, but on the owners as individuals. So they didn't pay the corporate tax, but instead the income tax. The disadvantages of partnership: first, the business liabilities are unlimited, which is involve personal assets of all partners of the company, just like sole proprietorship just now. The lifespan of the partnership business depends on the lifespan of the partners. If any of the partners pass away or is declared as bankrupt, the business is automatically dissolved unless there is an agreement otherwise. So it is important to have a partnership agreement that saying if one member pass away, the business can still continue. If no letter of agreement is being made, unethical or misconduct behavior may happen. Normally in partnership business, we tend to invite our family members or our friends to be a business partner. So at first, there is no issue of trust, but it is very important to prepare the agreement to avoid any misconduct behavior in the future. In the partnership, there is a risk of personal clashes among partners too. Even if you do business with your best friend, the tendency to have personal clashes between you and your friend still exists. So please, if you plan to do partnership business, very, very important to have a clear agreement. We will see what is the items should be included in the agreement in the next slide. The Business Registration Act 1956 does not specify that the formation of a partnership business must be followed by written agreement among partners. However, it is necessary for the business to have some kind of contract or partnership agreement to avoid any misunderstanding that may occur among partners. Some of the important elements that need to be stated in the agreement, of course, one is the name of the business, the duration of the partnership or the duration of the business. This is to prevent the dissolution. And the agreement should also state that in the event of one partner pass away or withdraw from the partnership, the business will not be dissolved. Saying to in the agreement, the individual involved in managing the partnership business, the account of the business and share capital that show the contribution of each partner and the right and obligation of each partner towards the capital. The capital here refer to the land, building, vehicle or any other fixed asset contributed by the partner for the use of the company. It should written clearly that all the assets are considered the asset of the business, the company. If partners do not have their own agreement, the provisions of the Act will become applicable. Section 26 and 27 of the Partnership Act 1961, among other things, stipulated that the following must be provided for in a partnership agreement. First, the profit and losses are to be shared equally. No interest is payable on the partner's capital. Okay, for example, just now, if the partner contribute a building or vehicle, so the partner cannot charge interest to the company. Each partner is entitled to actively participate in the management of the business, state clearly the tasks and responsibility of each member or partner. No partner is entitled to a salary for participating in the partnership business, but they have right to be paid based on their contribution to the business. So if their contribution is larger compared than other partner, so he or she will receive more compared to other members. The daily normal things in business can be decided by the majority of the partners, but any changes that regularly occur need to be made with consensus from all partners. A partner may withdraw from the partnership business after getting the consent of other partner. And if you plan to add a new partner, so you need consent from all existing partners or unanimous consent of all existing partners. All business accounts books need to be kept at the main business premises. Partners are allowed to check through the books and they have right to keep a copy of the books. But the original copy or the master list must be kept at the main business premise. How to register the sole proprietorship and partnership business? These two entities can be registered with the Business Unit of the Companies Commission of Malaysia (CCM) or Suruhanjaya Syarikat Malaysia (SSM). A business is allowed up to 7 days after the start of its operation to be registered. For more details about the procedures, you can log into the SSM website, okay, as given by the address here. Sometimes certain applications are turned down. This is because the applicant does not use capital letter when filling out the application form. So it's very important to read and understand clearly the instruction given on the form. The application form submitted is too dirty or untidy. The corrections are made using liquid eraser. Then the business is already registered but the owner has not taken any initiative to terminate the existing business before applying to register a new one. But if you plan to register more than one, especially if conduct different types of business and different name, you are allowed to register more than one. Another reason why your application is turned down because of verification of application form has been made by unauthorized personnel. The applicant does not attach a copy of the approval letter from other respective agencies in the case where the business is required to have other licenses or permits, or maybe you have to submit extra documents, but the approval letter is not attached, and other things that may cause the registrar of the business to have doubts. The third business entity, which is common in Malaysia, is private limited company. Private limited company is different than the other two just now. Okay, in private limited company, this business are set up under the Companies Act 1965. Okay, this company is a corporate body. It has characteristics that differentiate it from a sole proprietorship and partnership. This is because a private limited company is a legal entity and its identity is separate from the identity of the company's members. The characteristics of private limited company: first, the right and responsibility. A company has a specific right and responsibility. It can acquire assets under its own name. A company can also take legal action and face legal action under its own name. So if the company want to buy asset, for example, a building or vehicle, then that asset can be registered under the company names. And if any issue arise, the legal action is under the company's name. The lifespan. The lifespan of the company is not dependent upon the death or resignation of its members. A company can be dissolved when its members are no longer interested in continuing the business. So if one of the members pass away, the business can run as usual. Unless all the members agree to dissolve the business, then they can stop from continuing the business. The liabilities, which is hutang. The liabilities of the members in a company are limited to the total share contributed to the company's capital. So if you contribute much in the company's capital, so more liability burden falls to you. But your personal assets, for example, the house, the land, are not affected regardless of what happens to the company. If the company closed down or facing a huge debt or bankruptcy, your personal assets are not affected. The membership. A company must have at least 2 members who are of Malaysian citizen. These 2 members can act as a director and founder of the company. The member of the company will then appoint the board of directors who will manage and run this business operation. This is subject to the Companies Act 1965. The terms and conditions, syarat-syarat for private limited company. The number of members must not exceed 50 people. And it has specific authority to transfer ownership of members' shares with the approval of the company's board of directors. A company is not allowed to offer or sell any share or debenture to the general public. Debenture is like a certificate or just like a bond. You lend money to the people and we receive that money with the interest. So it is not allowed in this company. And it is not allowed to offer general public to deposit money within stipulated time frame. And the company must use Sundian Berhad at the end of its name. If you plan to set up a private limited company, make sure you have all of this. First, the Memorandum of Association. It is a document which stipulates the power and limitation of the company. For example, in that memorandum states the name of the company as approved by SSM just now, and then the registered office address, a statement that acknowledges the intention of the founder of the company, and agreement to take with. So the Memorandum of Association is actually the document that explains the company's business activity as well as its power and limitation. Other important requirement is Articles of Association. This document outlines the internal management policy as well as powers and responsibilities of the board of directors. Among the key items that the articles cover are the meetings of company members, responsibilities and power of the board directors, and also the secretary responsibilities and other things. The share capital of a company, there are authorized capital and paid-up capital. The authorized capital is the maximum limit of capital of a company. This capital must be recorded in Memorandum of Association and Articles of Association. Paid-up capital is the actual share issued to the members. It is part of the authorized capital to the members to be paid by them. It is also a major source of the company's financial requirements. The members of shareholders. The members of the shareholders, these members do not own a company, but only the shares of the company. The functions as well as the rights of members are discharged through the annual general meeting, as provided in the Articles of Association. In the annual general meeting, the approval of member is needed for item, for example, if you want to amend Memorandum of Association or Articles of Association, and if you want to add share capital to the company, change the names of the company, or to get approval of the honorarium payment to the directors, to appoint the company auditor and other things. The board of directors. The responsibility is to control the affair of the company so it operates effectively, depends on this board of directors. Each company is required to have at least 2 directors whose nationality is Malaysian. So in general, the director of the company is defined as a trustee and company representative. He or she also responsible for any fault committed by the company. Company secretary is a must in the company, so it is compulsory to hire a company secretary. The responsibility of this secretary is to make sure the running of the company is in line with the requirements of the provisions of the Company Act 1965 and aligned with the Memorandum of Association, Article of Association. Among the tasks of the secretary is to update all information into the company's register, such as shareholders registration, minutes of meetings, and so on. The auditors, it is compulsory too for a company to appoint a qualified auditor approved by the finance minister. However, this auditor is not allowed to hold any paid position in the company or work together with any officer in the company. So these auditors are the outsider. You only hire them for their service. So they are not your permanent staff or they will not receive salary monthly. Then of course, if you have private limited company, you should have registered office, a company seal and authorization letter. If you have authorization letter, then any representative of the company can participate in any written contract and signs on behalf of the company. The advantages of private limited company: first, funds are easy to acquire through exchange of share ownership or loan from financial institution. All shareholders are legally protected by law. Shareholders are not burdened with the management of the business because they hire board of directors. So this board of directors will manage and run the business. The liabilities of the company's members are limited to capital that they contributed to the company, and their personal assets are not affected. The lifespan of the business is not dependent upon the age or resignation of its members, so the business still can continue even if the member pass away, and it has a greater potential for expansion, and legally the company is one business entity by itself. The disadvantages: the private limited company is subject to more rules and regulations compared to sole proprietorship or partnership because this business is more bigger, more complicated as compared to these two. So that's why it is more rules and regulations that the company must abide. The company's share cannot be transacted through the share market, and this company pay corporate tax, differ than sole proprietorship and partnership. The qualified auditor must audit the company's yearly financial statement, and the statement must be complete and regularly updated. The financial affairs of the company must be made transparent to the general. So if you notice, the private limited company, they publish annual report yearly. In that report, the financial statement is provided to the public. And of course, the cost of setting up the company is high as compared to the other two just now. So to register the private limited company, it is a must to hire a secretary. Then this secretary will compile all the documents, then forward to the Suruhanjaya Syarikat Malaysia or Companies Commission in Malaysia. For more details, you can read the document by SSM doing business in Malaysia. The next video is part 2. It is about business formation.